Good afternoon, everyone. We are calling our board meeting to order for the Speech, Language Pathology, and Audiology and Hearing Aid Dispensers Board at 1:01 p.m. on December 4th. I will start with calling roll. Myself, Gilda Dominguez, present. Dr. Amy White.
Present.
Mr. Todd Borges.
Present.
Dr. Tamara Chambers.
Present.
Ms. Karen Chang.
Present.
Mr. Francis David.
Present.
Dr. Charles Sanders.
Present.
Thank you. We have a quorum. I'd like to also ask Ms. Sharice Burns to announce who is present from the board office staff.
Thank you. Sharice Burns, Executive Officer for the Hearing Aid Dispensers Board.
Good afternoon, Yuping Lin, Board Counsel.
Maria Liranzo, Ledge Reg Analyst.
Thank you.
And just a little bit of housekeeping. Bathrooms are on the outside, so you have to go out the front and around. Okay, and then make sure you push to talk for the microphone so that the webcast gets you.
Okay, thank you. I'd like to move to agenda item 2. First, like to thank you for hosting us here at Cerritos College and your fabulous speech language pathology assistant associate degree program students. We appreciate you opening up your doors to us today. I'd like to thank and also welcome Ms. Susan McDonald, there you are, who is the Department Chair and Program Director for the Cerritos College Speech Language Pathology Assistance Program. And I'd like for you to approach the table and provide your presentation to us that you have for us. Thank you. Absolutely.
Check. This way I can walk around. Speech Language Pathology Aid Certificate as well, which actually stacks into the Associate of Science degree program. So our students acquire some prerequisite coursework, and then they are able to apply to admission for the associate's degree. Once they're admitted to the program, they complete 2 more semesters of coursework, which includes their clinical fieldwork. And so their clinical fieldwork, I feel like, is very special for us in Cerritos because we partner so closely with our community organizations such as school districts and local speech and language clinics. So really it's such a partnership and such a pathway to employment. That's one of the most powerful things I think about associate's degree programs. We really prepare them to work with the local community and at a level where we're really training them for the workforce. So there's lots of amazing connections and employment opportunities that come from that. But of course, it wouldn't be possible without our accreditation from the board. So again, we're so glad to have you here. Our students had a little greetings they wanted to send to you. And I'm gonna just make sure I can get this going here. There we go. So if you can turn.
Hi, my name is Nia Boudreau, and I'm a student in the SLIPA program at Cerritos. One thing that led me to the speech therapy field is my work as an interventionist and paraprofessional in surrounding school districts. I've always loved working with small groups and have been interested in knowing more about AAC and individuals with disabilities. It has been a pleasure learning how to work with different age groups and populations. After graduation, I'm looking forward to making a difference in students' lives and seeing them succeed in speech and language. Thank you so much to the board and the program for giving me this opportunity.
Hello, my name is Maria Marisco. As I am about to graduate in just a few weeks, I would like to thank the board for making this experience possible. Reflecting on these past few years in the program has helped me realize the importance of becoming a speech and language pathologist assistant. As I move forward in my career, I aim to help my students or clients advocate for themselves and become more independent. This career has been gratifying, and I look forward to continuing my journey in helping others. Thank you.
Hello everyone, my name is Angelica Torres. The reason why I decided to become a SLPA was because I wanted to better my education, better myself, better my future for my child. My cousin is a SLPA. She advocated very highly in the field. And so I want to thank the board for giving us this opportunity to have the program for us to expand our education and to realize how important communication is for everyone. So thank you.
Hello, my name is Teresa Lepe. Becoming an SLPA for me means opening the door to a career that I can help people communicate verbally and confidently. It will also give my family and myself an opportunity to build stability and to give back to the well-being of my community. I would like to thank the board for giving the opportunity to share. Thank you. Bye.
Hi, my name is Ava Rodriguez, and I'm a student in the Cerritos College SLP program. So becoming a SLPA to me means a lot, especially as a first-generation college student. I grew up with many family members who needed speech therapy, and so I saw how firsthand life-changing speech therapy can be. The speech therapists have actually encouraged me to actually become a part of this field, so I'm eternally grateful for it. And this opportunity not only creates a better future for me and my family, but also allows me to give back to my community. So thank you for the board for making this possible.
Hello, my name is Vivian, and I am in the SLPA program at Cerritos College. For me, being a SLPA means helping the community by showing up for individuals who need a voice, whether that voice comes through speech, gestures, AAC, or any other form of expression. By providing compassionate, evidence-based support, I can help families access resources, help students succeed in school, and help all individuals build skills that open the door to meaningful relationships and to independence. Thank you for making this program possible. Together, we are strengthening communication, one interaction at a time.
Hello, welcome to the SLPA program. My name is Zazia Orantes, and I want to become a SLPA because I've always felt a calling to help children and their families, especially supporting them and advocating for them in their communication needs. And through my line of work and my coursework, I learned how essential communication is and how many families feel unheard. And I want families to know that their child does have a voice, whether it's spoken through an AAC device, a communication board, an app, or any other method. Communication is and always will be possible. And it's because of those reasons that I decided to join the SLPA program. And I want to give a huge thank you to the board and to the SLPA program for allowing this to happen. So thank you.
So I want to thank the students that were involved in coordinating just our welcome for the board. We have Vivian, Teresa, April, Angie, Liana, Leslie, Maria, and Mia. So thank you so much. And they also have prepared some displays for you to take a look at. If you haven't already, check out the different kinds of materials and activities and tools that we use to help individuals communicate through their speech and language sessions. So anyway, that wraps up my welcome, and I just want to say thank you so much, and we're excited to be with you for the next day and a half, so enjoy.
Thank you very much. I saw some familiar faces on the screen, and I really do appreciate your enthusiasm and your desire to make a change in everyone's lives that you are interacting with, students, their families, their support circle. So very impressive, and again, thank you for hosting us. And I'd like to ask if any of the board members have any comments as well.
Really quick, if it's okay, as executive officer, I just want to thank the program for all the work that you're doing with your students, for hosting us today and giving us some insight into what you're doing at your program. And we look forward to visiting other programs throughout the state when we go to meetings. So this was a wonderful first time that we got to do this, and it's been fabulous. So thank you so much. And I would just like to say, we're all here because we feel compelled to serve. Serve our patients, our clients, our communities. And that's what most of us on the board, that's why we're here on the board, to serve everyone, licensees and the consumers of the state. So keep up that feeling of wanting to give back and service throughout your entire career, and it will get you very far. Thank you for serving.
I'd like to ask if there are any other comments from anyone in the room before we proceed.
At this point, if anyone in the audience wants to come up and say anything to the board, you're more than welcome to come up to the microphone as well. You don't have to, but it's an opportunity.
Hearing none, we'll move to agenda item 3. Public comment for items not on the agenda. I'd like to ask for public comment from anyone in the room that would like to bring items to us that are not on the agenda.
I have one that you read as well.
Okay. All right, for you. Okay. All right. I'd like to ask anyone from the board membership or the board office staff if there are any items not on the agenda for discussion.
Absolutely. So we received a letter from CASHA, the California Speech Language Hearing Association. It was submitted via email prior to the board meeting. So this is from Benjamin Reese. He's a speech pathologist and vice president for advocacy for the association. And it states, I'm writing on behalf of the California Speech Language Hearing Association. Over the past year, our association has received numerous complaints about practices employed by Kaiser Permanente in their provision of speech and language services. Based on these complaints, we formed a committee to investigate and discuss the issues. The findings of this committee have been quite concerning and prompted us to seek counsel and collaboration with the American Speech Language Hearing Association. I'm reaching out to the licensure board to inform you of our concerns as we believe recently implemented practices by Kaiser limit access to services and potentially harm our consumers. CASHA's investigations reveal several concerning practices by Kaiser Permanente NorCal. We have received complaints regarding the following practices from Santa Rosa, Sacramento, the East Bay area, and San Jose. Our investigation and information gathering is ongoing. Some of our concerns include Kaiser Permanente episodic care mandates, in quotes, breaks in care. This means that patients receive speech-language pathology services for a short duration of time, followed by a break in service provision, regardless of progress or clinician recommendations. Kaiser Permanente requires reassessments to be conducted by Kaiser-employed speech-language pathologists rather than the treating vendored speech-language pathologist. Kaiser's SLP staff is limited, causing delays in assessments being scheduled, resulting in delays in service provision. Assessments are often limited to a phone conversation between the Kaiser-employed SLP and the parent, with no direct interaction with the child. Kaiser Permanente forces vendored SLPs to recommend reevaluation or discharge at any time, regardless of progress or recommendations of the treating clinician, in order to bring patients in-house, in quotes, for treatment. Kaiser Permanente is mandating speech-language pathology services provided in-house rather than using vendors, even though they lack the SLP staff to do so. This results in reduced frequency of speech-language therapy sessions, delays in scheduling, sessions scheduled and later canceled because of lack of staffing, and patients not having a consistent provider. They may see a different SLP for each visit. Kaiser Permanente limits authorization periods for Medi-Cal patients or clients to 90 days and requires vendored SLPs to file reauthorization requests to continue service. This practice results in administrative delays and breaks in service to Medi-Cal clients, a violation of early and periodic screening, diagnostic, and treatment EPSDT regulations. CASHA is working with ASHA to raise awareness of Kaiser Permanente's episodic care practices and how these practices are a violation of EPSDT regulations, private insurance regulations, and ASHA's SLP Code of Ethics violations. We are informing you, our California Speech Language Pathology and Audiology and Hearing Aid Dispensers Licensure Board members of our concerns. We anticipate complaints to be filed with the Licensure Board in the coming months. We are also anticipating complaints to be filed with the California Insurance Commissioner's Office. CASHA and ASHA have a planned meeting with Kaiser Permanente officials in December to discuss our concerns regarding EPSDT violations. Should you have any questions regarding our concerns or our investigations into this issue, please feel free to contact me. Sincerely, Benjamin Reese. And so that was the submitted public comment that we have that's not on the agenda.
Thank you. Any other public comment for items not on the agenda? Hearing none, we will now proceed into recess for our first committee meeting. Take 5 minutes. We'll reconvene in 5 minutes. Thank you.
So at this point, if you are not on the Speech Language Pathology Committee, go ahead and sit out towards the audience and or sit at the table is fine.
4th, 2025, we're calling to order our Speech-Language Pathology Practice Committee meeting. First, I'll start with roll. I'm President Gilda Dominguez, Chair. Dr. Tamara Chambers.
Present.
And Mr. Francis David.
Present.
We have a quorum. I'd like to move to agenda item 2 for public comment for items not on the agenda. I'd like to ask for public comment for those present in the room. All right, hearing none. We'll move to agenda item 3 for discussion and possible action to amend regulations regarding scope of responsibility, duties, and functions of speech-language pathology assistants related to swallow therapy as stated in Title 16, California Code of Regulations, CCR sections 1399.170.1, 1399.170.2, and 1399.170.3. I'd like to ask Ms. Lorenzo to present this agenda item at this time.
Thank you, Ms. Dominguez. On November 30th, 2023, the committee discussed restrictions on SLPA performing oropharyngeal swallow therapy with bolus material. The committee met on December 5th, 2024 and May 15, 2025 to determine if SLPA should be allowed to perform swallow therapy with bolus material by comparing neighboring states and national requirements and requirements of other healing arts professions such as occupational therapy. The committee determined that SLPAs should be able to perform feeding and swallow therapy with bolus material and began discussion on possible requirements that would allow them to do so, such as requiring a specified number of hours of experience under immediate supervision before SLPA can perform feeding and swallow therapy with bolus material under direct supervision, requiring SLPA to perform feeding and swallowing therapy with bolus material in specific settings, and prohibiting SLPAs from performing feeding and swallow therapy with bolus material on patients with contraindications, and specifying those contraindications would be. The committee met on August 21st, 2025, to continue discussing possible requirements that would allow SLPAs to perform feeding and swallow therapy with bolus material, such as requiring a specified number of hours of education in swallowing dysphagia and anatomy and physiology of swallowing from an approved continuing education provider, requiring the supervised experience to be from direct client care with patients that cover all phases of swallowing and a variety of ages, requiring the supervised experience to be under the supervision of a SLP licensed in California who performs feeding and swallow therapy with bolus material as part of their practice, requiring a written verification of competency, education, and experience to include the SLP signature and license number, and requiring documentation of approval that a SLPA can provide feeding and swallow therapy with bolus material to a patient be from a California licensed SLP who performs feeding and swallow therapy with bolus material as part of their practice. The committee directed board staff to draft regulatory text to remove restrictions and specify requirements for SLPAs to perform feeding and swallow therapy with bolus material, which can be found as attachment A in the meeting materials. We do have a couple discussion questions to clarify some areas of the text, as well as verify the intent of the requirements, and as well as some meeting materials to help aid with that discussion. Thank you.
I think it would, I'm sorry, Sharice, I'm sorry. Okay. Why don't we start with going through your questions, and then that'll guide our discussion and our responses. So we can start with the first one that you have.
Do you want me to direct the questions?
Yes,
or
why don't
would
you initiate, yes. And
All
then
right.
we'll
Yeah, so our first question is in section 1399.170C1 regarding the SLPA who signs the verification. So we're looking at the text. And the question is the SLPA who signs the verification the same SLPA who provides the immediate supervision, the required 100 hours?
So in this question, I think what Maria is getting at as well is that it might be someone immediately supervising while the person is doing the swallow therapy, and they might be signing off each and every time doing that immediate supervision. But does the person who signs off at the end, the 100 hours, need to be that same, and not SLPA, but SLP who's signing off? So what you might see so when we talk about the flexible endoscopic evaluation of swallowing, a lot of SLPs go and get this certification or written verification by doing 25 passages, but the person who's supervising might be different for the different ones, right? 10 have to be from an otolaryngologist, and the rest could be from an SLP, but they may not be the same person. And then that last written verification that says, yes, this person is competent to do swallow therapy with bolus material on these patients, does that need to be the same person, or can it be someone else? They'd be verifying the record. So that's the question here, because we aren't very specific in how we do the fees procedure. So we do see a lot of variety. So in the regulations here, we kind of want to fetter out, what is the board envisioning? Is it similar to what the SLPs are doing now, which is it might be a variety of people signing off on each passage, and then one person who's separate maybe doing the last written verification?
Thank you for the clarification. I was looking at that. So each bolus trial will be co-signed by the attending speech pathologist. Is that correct?
That's what we're seeing now on the
Okay.
fee side. So it'll have a bunch of, this is when the passage was, here's the person who signed, here's the person. And so it's a bunch of that, if we do see it at all, right? Because they don't have to provide it to the board. But what we're seeing is that, and then a separate person is saying, yes, they've done these 25 passages successfully. For the SLPA, that would be, yes, these 100 hours, which if each swallow therapy with bolus material is a 1-hour therapy session, that'd be 100 sessions. So you'd see 100 signed off sessions.
Okay.
And then that other person would be saying, yes, there were no concerns, there was no reports back from any of these people, these are all okay.
Okay. Would there be a possibility that the final signature has to consult with all previous signatories on all of those, just to verify all of those?
I would say that's something that you can require.
I would think so.
We would want to specify that in regulations, because as currently written, it doesn't say that. It is, I mean, it's best practice that that's what you should be doing,
Yes.
but if it's not written, then not everyone's gonna think that that's what they should be doing. But yeah, I mean, if that's something you want to make sure that the level of quality and
Absolutely.
safety standards are there, then yeah, we would have to specify that in the regs.
Or is it possible also we have the one with the most number of observations with this SLPA be the one to do the final signature?
My hesitation is you might see a very big variety when this comes to fruition,
Okay.
right? 100 hours is a lot.
It is a
That's
lot.
100 that's 100 instances of the swallow therapy. So you might see they're at one clinic doing this, they're at another facility doing this, they're at another, and then you might see a variety of SLPs at those clinics signing off, and then maybe it's their main supervisor who's the one that's doing the actual sign off. Now, I wouldn't even, I don't know that we would want to mandate that that SLP also be somebody that's signing all the rest of them, but that could be something you do. But again, the hard part with regulations is the more specific and into the weeds and detailed we get, the harder the restrictions become. And so sometimes a perfectly acceptable situation is set up to make it easier on those SLPAs to get those 100 hours, but then maybe it wouldn't meet our rigid criteria. So we always want to kind of be looking at the regulation. We want to make this possible. We want to make SLPAs to be able to provide the swallow therapy just like occupational therapy assistants do. Do we not want to be overly prohibitive in the way to get there? So,
You know, and to your point, if we have to be mindful of that, because if we ask for the SLP who did the majority of those observations or those trainings, what if they're no longer working at the same site that SLPA had been training at, and maybe they moved out of state, or
Point taken.
so it would be very hard to obtain maybe that verification from that speech language pathologist, or again, if they're no longer working with each other. So maybe it's their main supervisor that does the ultimate sign off, and knowing that they're going to be looking and observing and assessing the competency before they sign off themselves, because ultimately it's their responsibility, right, to make sure that they're following regulations and staying within scope. So that would be my feedback, is that I suggest that it would be the supervising SLP do the final sign off for the SLPA.
and then I would just also recommend, because of course, as the executive officer, I see a lot of random things, right? So we do occasionally have someone who the supervisor of something might have died, unexpectedly
Yes.
passed away. So we always want to be careful not to put in something that would ultimately prohibit that. So
It's also my understanding that it's like, this is like a once and done deal. So it's, I mean, they would have, ideally, hopefully the SLPA has a copy for their records. The supervisor has a copy for their records. And if they're moving to different jobs, maybe that copy gets into their files. So, but, everyone has to, I have a military background, so it's, we always make copies of documents, but, there are some, employments that might do that. I think, let's see. So I guess my question is, to get an idea. So is the idea is that this training is kind of, which I think might be one of the questions, because I'm trying to envision what this is going to look like. So it sounds like, from like the regs we put together, it sounds like this kind of training is going to be more a workplace training, where that they're doing it with a SLP who's doing feeding and swallowing. So it does make sense that the supervising SLP should be the one writing the verification, because that's where it's, according to our regulations, that's where it's going to be happening the most.
Yes, I agree.
And then knowing that SLPAs will probably have multiple supervisors, then they could do their immediate supervision under the different supervisors.
Yes.
But that the supervising, the primary supervisor will be the one writing that verification. So that is something we could do.
And I guess if something happens to that primary, if they have multiple supervisors, and one of them can do the verification.
Yeah. So I mean, they're they're supervisors. It's just, we could specify that the supervising SLP will be the will be the one writing it for them.
Any other comments on question 1?
I just really like that, because that way, you want them to experience different settings, you want them to have these different experiences, these varied experiences, but the idea that they are ultimately reporting to someone and that person is signing off on them, I like that you still have that oversight, that continuity, but you still maintain that diversity in their experiences at different locations, potentially with different oversight.
That's great. Yeah. Thank you. Okay. Okay. Do we want to move on to question 2?
Yes, we can move on to question 2. So for question 2, should 1399.170.1C4 also include willingness to cooperate with the examination as a contraindication? Currently, the list has severe movement disorders, severe agitation, and inability to cooperate with the examination. So our question is that does the regulation need to specify if they're unwilling to cooperate, or is it covered in their inability to inability to cooperate with the examination?
And I can ask this of you, Francis, but again, even in speech therapy with little ones and SLPAs are working with them, I'm sure they encounter clients that are unwilling, and there are ways that they get them to be more willing. But do you agree that this is a parallel to that, or is this something that would be more of a different situation where the unwillingness would be more detrimental?
Based on experience, unwillingness and refusal are two different things. There are people who are unwilling to do something but will probably still do it, and then there's the refusal to do. If a patient, I think, would refuse to have any sort of bolus trial, that would be something that we cannot do any. I can't force somebody to take a bolus. Unwillingness is, there are some ways we could probably do some behavior modifications or some type of interventions for those. So if they plainly refuse, I wouldn't personally try to introduce bolus materials if they already verify that they refuse to take it. Your thoughts, Gilda, on that one?
Yeah, and doctor as well, unwillingness versus inability.
Yeah.
I think what you're getting at is inability, like maybe physically, like the patient cannot do it, versus something that maybe is coachable, or you can walk them through and try and behavior, and whether or not there's strategies that somebody would be able to employ to get them to do whatever you're trying to get them to do. So should they be separate? Potentially they should. Inability or versus and unwillingness to cooperate with the exam, maybe an additional.
Because SLPAs may already be in a situation where they're trying to pull a behavior out of a child, for example, to participate. Oral feeding, I think is a different situation.
I think that's a different situation because you have bolus material, you have the swallowing process in general, and there could be some more repercussions if you.
Right. And there might be a tendency to possibly changing the treatment plan if you're dealing with someone who's unwilling to participate, and SLPAs are not able to change a treatment plan. They have to follow the direction of the SLP's plan of care.
Yes.
Right.
So as a goal, they might have to go to their attending SLP and say, I cannot do a bolus trial at this time. Maybe we should focus more on the education. We should focus more on
maybe the oral motor.
The oral motor part. Maybe we should focus on at least tolerance to therapy in general.
Caregiver education.
Caregiver education, right.
And the SLP needs to have that initial contact with the client or the patient that they're handing over, right? That they're having the SLPA continue therapy. So they will technically have the initial exposure and know the temperament and know the client or the patient's ability to participate first before having the SLPA continue the therapy plan. So it might be a halt
It might be a
from the
halt,
beginning.
yeah.
Yeah.
So
I don't know, oh,
so maybe it sounds like we might want to put unwillingness just to like red flag, like,
Yeah, red flag, yeah.
you know, as a note that if, especially when working with children, that
Even
you don't
adults.
want to try to maybe push
Mhm.
too hard,
Mhm.
without the SLP
Yes.
involvement.
Yeah. Or even adults. Because I do think adding this into the SLIPA scope of practice would also expand the age range. You know, ASHA says that this isn't a scope. We're supporting that scope. We just want to make sure that there's clear parameters, whatever age that the client is.
Yes, all right.
Okay. Any other comments from the
Not at
committee?
this time.
Okay. Would you like to move to question 3?
Yes.
Okay.
So as currently written, the proposed requirements are very specific and could limit the professional community from creating education and/or experience opportunities for SLIPAs to become competent to perform feeding and swallowing therapy with bolus material. If the text moves through the rulemaking process, board staff can keep an eye for comments from the public on this issue. However, we do want the committee to consider the following before recommending the text to the board. Do any of the following create barriers to SLIPA to obtain education and experience? And so that would be requiring education from an approved CE provider only, rather than allowing education from an employer who may not be an approved provider. Requiring supervisor experience to be under the supervision of a licensed, California licensed SLP only, rather than supervision by an SLP licensed in other states. And requiring supervised experience to be from direct client care with patients only, rather than allowing supervised experience based on work with students, volunteers, or mannequins.
Okay, that's 3 questions in there.
Yeah.
So I'll start with the first one. First bullet point regarding requiring education from an approved CE provider only, rather than also allowing education from an employer who may not be an approved CE provider. And you're referencing the 45 hours in this section?
Yes.
Okay.
Yeah, I'm not sure, you know, I'm thinking this will probably start maybe in hospital settings. So I'm not sure if they will want their own doctors or SLPs providing a course on anatomy or physiology, like a workshop or something like that. That could be something that could be put together, but I don't know how that works in the hospital setting when it comes to education.
So again, we often, as staff, we look at what do we know, right? What do we know currently? We see fees programs where they will come and do a conference, or it's done at their hospital, or it's done at a workshop that they go out of state for. And is it going to be those hours, that 2 days of training or 3 days of training, or an entire semester course? How all do we want to allow this, especially if hospitals do take it on, or some other employment-based? Do they have to come to the board and become an approved CE provider first, and in order to do this, or is it acceptable that their place of employment would be doing this? It begs a lot of questions. We can always set parameters for what then is required. It has to meet certain criteria or something like that, but again, the more we limit it, the harder it will be to get it done. So right now, the fees does not, there's no required additional education, but usually there is an educational component, right? It's a 2-day experience, right? So they do some training on that, and then the next day is when they're doing some supervised passages of the endoscope down the throat, right? Or up the nose and down the throat. Up, down. So, when we're thinking of it as staff, we're also trying to think, what kind of models might be developed in the meantime? Because right now, of course, our SLIPA programs don't include this education component at the moment. which may eventually be resolved, right? But right now, if we're going to start allowing this, then what forms might this take? And becoming a CE provider approved by the board, it's not hard, but again, like it does make an additional restriction on it. I do have quite a few school districts who have now become approved CE providers so that all the trainings they do for their SLPs and SLPAs counts, right? But that's another step. I also have some people who took all those courses in that situation where the facility you work at said, oh yes, we want to train you in this, but then there's not really an easy way, especially if you're in a rural clinic, to go and get this training. What's going to be required, or will it be overly burdensome? I've got to go out of state and fly to this thing to go get it done there, and then hopefully the board will approve it because they're a CE provider or whatever, or they're approved by ASHA, so they're exempt from our CE, you know what I mean? So they're still allowed. So.
How feasible is it to approve a CE course without having a hospital or a clinic be a CE provider, or a clinic owner being a CE provider?
The board does not approve CE courses for speech and audiology. We approve courses for hearing aid dispensing only. Right now, we approve providers. You apply, you get approved as a provider for 2 years, and you have that registration so that you can provide CE for those 2 years, and then you can renew. It's different on hearing aid dispensing where it is course by course. Very different than the way we do it in speech and audiology. So currently in this regulatory section, you don't have that structure. It doesn't exist on this side.
Thank you, I wanted them to know that.
No worries. Always happy to educate.
I think that they should be offered by a CE provider only or through the organizations that are exempt.
I agree with that one because that helps us with the fidelity of each of the courses that they have to take.
My only thought is, I work at an academic medical center, right? And so if you have a laryngologist who gives a course in something that would that would not get credit, if we're not a otherwise institution that's CE.
CE provider.
Yeah, that's not a continuing ed.
So like a physician, an MD, laryngologist couldn't give a talk to allow somebody to get credit. So I think maybe that might be a little bit too limiting, but I don't know how to open it enough to say, like, my world-class academic laryngologist should be able to give such a course.
Yeah,
we're doing 45 hours, right?
45 hours. Yes, okay.
That's who I was
agree.
thinking.
Yeah.
I was like, oh, I could see like Dr.
teaching
Chambers
it.
teaching it herself, or an SLP doing it one-on-one with the SLPA they're going to supervise. So that's who I was thinking of. Yeah, and it would be, they could take the course, it's just they couldn't count it towards CE, and making sure that's, people forget to advertise that or clarify that you can't use these hours for your CE. So that is who I'm specifically thinking of regarding this point, is like an employer and an employee relationship in that setting, or in research hospitals where they do that kind of stuff.
So I do agree with that. I guess where I was thinking is that, so that would probably be a course that would be maybe advertised or shared with those who can come to your hospital to learn, versus someone in a private practice saying, okay, well, come on a Saturday and I'm going to teach a 2-hour course and this is going to be part of your CE credit. But if it's something that's maybe attached to a teaching hospital.
Sharice might know. Are hospitals part of the exempt folks, or?
They are not.
Are they part?
Currently, the exempt CE providers are ASHA,
The
American
universities?
Speech Hearing Association, the American Academy of Audiology, and the California Medical Association, those kind of providers.
And what about, I know, isn't university and colleges also exempt?
University and colleges is, but that's not always going to be
A hospital?
The hospital.
All right.
So that's going to be the university itself. And even then, you could have a children's hospital that's not attached to a university. So wouldn't Rady's Children's Hospital down in, I think it's San Diego or wherever it's at? Yeah. Maybe they want to start training their SLPAs. That would, if they're not tied to a university, would that restrict it? I think that's where we're getting at is should there be employment-based, hospital-based training programs that are allowed that could be specified, so that it's clear that in this instance, yes, the SLPA can't use it for your CE when you get audited for your CE. Okay, well, you can't use it for that, but it counts towards your 45 hours to start doing swallow therapy with bolus material. So that, even though it wouldn't count for the other, that's okay. It gets them to a new level of services and expanding their scope for their practice. So that's really important for them. But should there be parameters? We want to, yes, have employment-based, but we don't want just pop-up clinics, maybe is my guess, right? You don't want just somebody popping up a thing on a Saturday to do some training. But if you're associated with an employment-based training or a hospital-based training, some sort of criteria like that we could flesh out, that might be worth talking about in the regulation.
I was just thinking about that. It would, because it's 45 hours, correct?
That's correct.
Would it be a possibility that we have to at least 30 hours would be from a CE provider and the 15 hours would be from another?
It might be a little tricky, but I do have a question for Dr. Chambers. Is your hospital a provider through, what is it, CMA? Because we are making statutory, or we're proposing statutory changes to include that. So as an exempt,
well, CMA does different for their categories, right? And so that might depend on how they do their courses. She can speak more to
And
that.
the other part of it is like, you know, as you mentioned, like employer-based. So like I'm in an academic medical institution, but I have faculty that are university-based that come over. And so, you know, is it tied to the place where you're doing it, the building, or is it tied to the person that's coming over to actually teach the course? You know, and like for us, like if I give my SLPs, if we have a lunch talk, you know, does that count? Not at all, because I don't fall into that category. But is it, you know, no longer worthwhile, or, you know, my world-class laryngologists, can they do such?
My only worry is that they're not going to be going to all world class, right? They might just say, oh, my friend's gonna, you know, have this lunch and learn at their house, and there's, there has to be some parameters.
So how can we quantify that? Which one could we, and that's the question that we have to answer.
I think part of it might also be in the question, you know, is it an employer-based training? So this is something that an employer is developing at their place of business for their employees, which hopefully wouldn't be just come on by my clinic on a Saturday if you want to come on down. Well, but hopefully they're your employee then, right? So if it's employer-based, you're an employee of that location, and it's not just a fly-by-night, come on, drop by, get a few hours here and there, and then go ahead and, I don't want to say it rudely, but like shove some stuff down somebody's throat and like, let's see. You know, like it's not that kind of a fly-by-night operation. So, but I mean, that could be, you know, it's a series, I'd have to look at our regulations, but like a structured coursework provided by an employer so that it kind of meets that more of a standard that you're trying to go for, which a structured sequence of coursework provided by the SLPA's employer or a university or a hospital, you know, something to that gravitas. And then we can kind of work with our regulatory council on fleshing out what some of those could look like.
Yes, making sure that there is a structure around that. There are clear parameters. And maybe even having it at an organization or a facility or an agency, because then there are owners of clinics that do work out of their homes. So where is this also being provided, I think is equally as important.
And I would say there is the eventuality that they would be providing some of the feeding therapy at least in the home environment, right? But I don't know about the rest. I know we are specifying in our
Just the employment, the
the
education.
certain facility types as well. So we're not just saying you can do all of this anywhere. But again, I think that's where making sure we look at other language and how we, it's a structured, sequenced coursework that's an employer-based or hospital, something along those lines. Just, again, it's not a free-for-all. It can't just be fly-by-night. Very serious. Because again, I mean, we also want to, on the alternate side, right, we want to make sure that if a SLP is going to get this education and verification, they are competent and confident to go out there and provide this therapy, and that they are not then going to feel that they weren't prepared well enough and unsupported when they end up out there doing this. And so I think it's got the dual purpose there.
I have a question for Dr. Chambers. So when you offer, or when those course offerings happen, those lunch and learns happen, are you allowing clinicians, speech language pathologists, or potentially SLPAs coming from outside of your work environment to attend as well, like opening it up to the community per se, or is it just for those who are employed?
Not necessarily, yeah, just for those that are employed.
Okay. Yeah. Then I think that would be fine as long as there's documentation that this is something that their medical office has approved as an offering. That's documented, how many hours that they will be getting. For example, because I know that physicians get, the CMEs, and they're listed on there, who's speaking. There's course objectives, and all that is met as long as there's a course evaluation, some type of way to assess what has been learned during that offering. Then I think that would be acceptable as long as it's from their own employer and there's supporting documentation that it was allowed to be provided for such purposes.
And just so everyone's aware, because this is a great educational opportunity, all of this comes down, and I know it sounds very down in the forest, right? We're down in the trees. We're talking very nitty-gritty things because as the board, we often aren't involved in much of the work you're going to be doing until something goes wrong. And we have a complaint. Something has happened to a patient, and now we're going to be looking at, were you correctly verified and certified in the first place to do this therapy that caused this child to choke and aspirate and so on? All those questions will come back to the board requesting said documentation. Show me the sign-offs. Where's your written verification that you were deemed competent to do so? How did you achieve all these things? And when we go backwards, did you meet the requirements? And so while it may sound very, very detailed and nitty-gritty, it's in the enforcement of these provisions that the board ends up in the weeds and looking at all of this. So that's when, we're coming to your hospital, your clinic, and requesting all of these patient documents, requesting all of the written verifications. We want to see this. We're then going to go interview the SLP that provided this training and this SLP who did these different therapies with you. This is where it comes down to that very detailed, important, and investigative and enforcement mechanisms. So, not that anyone ever wants to be there, but that's where it comes down to it. So.
Okay, thank you. Any other discussion on bullet point 1? Okay. We'll move to bullet point 2, requiring the supervisor experience to be under the supervision of an SLP license in California only, rather than allowing supervision by an SLP license in other states as well.
So here's where I'm going to bring up the fees again. So currently we do have oftentimes out-of-state providers coming in and doing the trainings. They may not always be licensed here in the state of California, but they're a nationally recognized person in whatever, and they're coming here to do that training for those multiple days with those people. And since we are specifying this, do we really want to prohibit that? And then alternatively, if you're in a location that this isn't offered very often, but you want to get it done, and you know there's a program in, I'm going to go with Oregon, I'm just going to pick a state, and you went up there, this person is qualified, they do a great training, and I can go up there and get it all done in my 45 hours in 1 week, I just do these multiple days, is that not acceptable? Because in fees, we do find where people travel to go get these seminars and then passages. So do we want to prohibit it just to California licensees? Because if they're licensed in another state, we can also request evidence and information from the other state they're licensed in.
Okay, so I just wanted clarification. I thought this bullet point was referencing the 100 hours of the therapy under the immediate supervision.
Yeah, that was
It is,
okay,
but you
so-
you could potentially also be doing, I went over and I did my trainings at this place. It also leads to the next one a little bit. So again, some of the fees procedures, they're going to this and then they're scoping each other rather than doing something with a patient. So I know this is not a one-to-one comparison, but that's where my thoughts went, is if they're getting passages and everybody volunteers to be everybody else's passage, which I know this is different, is that also acceptable? Where, okay, well, we got a number of volunteers and each student's going to try this with the other student and that kind of a thing. Is that allowed or is that not allowed?
Okay.
So it kind of, they're separate bullet points, but they're kind of touching at each other.
Okay, no, I just wanted to clarify also, which part are we talking about with regard to supervision of a non, so it's not the 100 hours, the 45 hours?
This is for the 100 hours.
This is for the 100 hours.
This is for the 100 hours. So the
So-
actual supervising of the swallowing therapy. But again, my brain goes to fees because that's what I know. And so that's where sometimes they're going and they're passing the scope through each other. And those are passages. Those are considered passages. So would some of those swallow therapies, if they're trying it with someone, especially the first 10 or something that they're going to do, might it not be on a patient, but on other students where they're practicing it on each other?
And so, and this point and the next point might not be relevant, because like I said earlier, it sounds like maybe we're looking at the 100 hours be done in like the workplace, like under like a mentor-mentee kind of relationship, which is different from the fees, which is, there's a workshop either in state or out of state. So like this point may not, because if they're providing cares to patients in California, obviously they have to be California licensed. So we just wanted to make sure, we just want to verify the intent, like the intent is that we want this training to be done maybe more in the workplace, because that's probably where the opportunities are until programs decide to pick up, all this stuff. And maybe, because in other places, in the next point I mentioned, like, Charisse was talking about volunteers and students. I came across like mannequins, like simulated mannequins. And so it's just like, is that something you would want as part of that 100 experience? But I know previously you've all discussed that you want direct client care so that they could have opportunities with different people, different ages. And so, we're just clarifying the intent. That way, when we're creating the rulemaking process, we have that, it's verbalized. And that way I can capture it in the rulemaking as to why it's written this way and why the requirements are the way they are.
And I recall in some previous documents that you had presented with regards to SLPA scope of practice in other states, there were several other states that didn't include feeding with bolus therapy as part of the scope. So my mind tends to think, okay, we need to ensure that they're also getting mentored by SLPs who in their respective states as well allow SLPAs to do this within their scope of practice as well. So there weren't that, I think, I don't recall.
Yeah, there was, yeah, she was mentioning about states. Yeah, I believe they had language similar to ours, which is similar to ASHA, and they probably haven't gone to it because a lot of states, they're like us, we're a small board and probably don't have staff to update the regs. So those could soon probably be updated. But yeah, I mean, I think, you know, looking at the text, they are required to do these in specific settings, so they would be like facilities in California because it's like a clinic licensed by Department of Public Health or something like that. So yeah, so it makes sense to have the experience on direct client care with patients in California by a California license, because of also the location that they could only do these.
And again, as the board, when we adopt regulations, we have to show the Office of Administrative Law that we have looked at as many alternatives as there are out there. Did we consider them? Once we considered them, what did we decide and why did we decide it? And we've decided for patient care, for competency, all the reasons why. So it's not that you can't place restrictions on things, but you need to have a valid reason. You've considered all the alternatives and here's why these things don't work. And so that's why we want you guys to have the conversation. Then, and of course, when you take it to the board, they've heard these conversations, they've read the materials, they understand why we've headed in the direction we've headed.
Thank you. So regarding bullet point 3, requiring the supervisor experience to be from direct client care with patients only, rather than allowing supervised experience based on the work with students / volunteers or mannequins. What are the committee's thoughts? We're going to keep with direct patient care?
I'd rather have it direct patient care.
Agreed.
Okay, yes, I agree.
We can move on to the next question, which is, should there be restrictions or specified requirements for feeding and swallow therapy for specific age, like newborns and infants or conditions, patients with artificial airways? I know last meeting it was mentioned, I think, neonates or someone used a specific term, and I was like, okay, well, let's, I just want to make sure we cover that before proceeding, like to make sure, like, is SLPAs, like, are there restrictions around SLPAs, especially because I know as I was doing research, it seems like a lot of feeding and swallowing is with infants and that age group. So yeah, just giving the committee an opportunity to talk about it a little bit more.
Good question. Even speech pathologists need to obtain additional training to work with those little guys, the neonates. There are specific coursework, certifications, NOMAS that organizations or hospitals are requiring that happen, and even additional hands-on training that's documented as a specific competency. And even the coursework is included in speech language pathology education, and then our clinical fellowship, our required professional experience. So I would be very cautious of allowing this for the neonatal, newborn infant population.
I'm also thinking of having several restrictions on just medically fragile. Those who are medically fragile, advanced airway also. That takes a lot more experience from, and there's a lot more training and certifications to do that as well. Some comorbid conditions also might be something that might cause that we might want to look at some restrictions.
What kind of
comorbid conditions
are you thinking of?
Maybe somebody with severe aphasia, or
yeah.
somebody
So
who's
we do have in the contraindications. I think that's where we had the discussion regarding cases of severe movement disorders, severe agitation,
cognitive disorder,
inability to cooperate. That's probably where we're gonna add and maybe age restrictions or things like that.
And also cognitive functioning, maybe it's something that might be important to add in that as well.
Would that be similar to inability to cooperate with the examination? Or is that something
It might
different?
be different because some of them might be willing, but cognitively they're unable to follow instructions. They're unable to actually answer yes, no. Do you feel anything? Is it anything going on? Cognitively, they might not be able to give you those responses. So
All right. Let's see. Any other contraindications?
I think those two are appropriate in addition to what Francis said.
So we're looking. How did you word it?
Cognitive level of functioning.
I'm thinking
With that-
cognitive level of functioning,
Patients with advanced airways.
Advanced areas. Yeah.
limits patients' ability to participate in the
Yeah.
therapy or something like that.
And then we're also, what, for the little guys, what do you call, what group or what word or term?
The neonatals one?
Yeah.
Neonatal?
Neonatals
Yeah.
/ infants. Mm-hmm.
So, yeah. How about medically fragile?
Medically fragile is already
Is that specified already?
specified
Thank you.
that, well,
Well,
that
in
they need,
general,
yeah, they need
100%.
supervision.
Is it
So-
100% supervision? That also includes tele, so I guess that's another conversation, so.
I mean, so the medically fragile would, they would fall into the contraindications, right?
Okay.
And so we're thinking of which medically fragile patients shouldn't be doing it.
or is it all?
Or is it at all? Yeah.
Because then we could say the patient is not medically fragile or has no contraindications. Because if it's just straight all medically fragile, patients should not have this being done by the SLPA, it should be done by the SLP only, then you could just state that outright before the contraindications that you're listing. So,
I don't have my law book on me. It's on, if you could let us know, Sharice, what's the definition of medically fragile?
let me get my close-ups on.
Thank you.
It says here a term used to describe an individual who is acutely ill and in an unstable health condition. If a SLPA treats such an individual, that treatment requires 100% direct supervision by an SLP.
And I understand that also includes tele-supervision, so that's another issue.
Well, they require to have, when they're performing this procedure, after they've complete their education and supervise, it will be direct supervision. So the SLP has to be in the facility.
Okay.
On-site.
On-site.
Facility. And just so the audience is aware, we have little law books. They're right over there in yellow, and they have the board's laws and regulations. I'm sorry, I don't have a ton of them. But the laws and regulations that govern the board and your operations and your scope of practice are all in the California Code of Regulations and the Business and Professions Code. You can also go to our website, and we have links on there that can take you to those code sections, and that's where you can find them. Or you can take, happily take one of the books in the back, and that has all of them printed just for this year, so.
Medically fragile is different, though, than a chronically, potentially cognitively impaired patient, because this is an acute patient, and someone can be chronically, cognitively impaired. So those are two different categories.
Thank you.
but under, there's the ASHA reference in here too, and they state that the supervising SOP must accurately document and regularly record all supervisor activities, both direct and indirect. Further, 100% direct supervision, synchronous or live tele-supervision is acceptable of SOPAs for medically fragile students, patients, and clients is required. So that's on that side, but for us, we want the direct, and we want them to be on site.
When
Correct.
performing this procedure.
Yeah.
And then our requirement for medically fragile is that the supervisor is in the room
Yep.
In
at
the
all
room.
times.
Yep.
Direct supervision.
Yeah.
We call it immediate
We call it
supervision in the
Immediate.
regulations, but yeah. So immediate is in person in the room with the SLPA, as where direct would be on site and available. Indirect would be they're not at the facility and they're available by phone.
So I'm tracking for number 4 to add in the contraindications in addition to unwillingness to cooperate with the examination, but also maybe a cognitive impairment, patient with advanced airways, and neonatal infants.
Neonates slash
Neonates and
infants.
infants. All right.
Okay. Any other comments from the committee?
No.
Okay.
And then the last question is, there's for education, it's swallowing and dysphagia. That may lack clarity for the rulemaking process. So what exactly about swallowing dysphagia should a SLPA know that would provide them with the knowledge they need to perform feeding and swallow therapy with bolus material? And I've provided an example like causes, signs and symptoms, screening, assessments, treatment, ethical consideration.
Essentially, should there be a
Anatomy.
couple checkoff criteria in there?
We need a little bit a descriptor of the course
Okay.
instead of swallowing dysphagia, because that could be just like anything and everything or one specific aspect of swallowing dysphagia. Yeah.
Anatomy and physiology
And that-
that
that's
comes
what
to
I was going to
mind.
say. I was going to say that anatomy and physiology is very important.
Yes, so we do have that. We have
Where is that?
on page 1 of 4 under B, we have education under section must be from approved provider, and course content must cover swallowing dysphagia and anatomy and physiology of swallowing.
Okay. Where are you? I have so many things out.
Treatment, ethical considerations.
Etiologies, causes,
Etiologies.
signs and symptoms of,
Types of, type of diet.
Hold on, can you repeat that?
anatomy and physiology, etiology slash causes, signs and symptoms of swallow dysfunction, aspiration. I think they do need to have the knowledge of what assessments are, even though they're not going to be performing them, and certain type of screening tools that are utilized. You know, the EAT-10, the MASA.
How about diet?
The
Type of
diet textures, liquid consistencies,
Yes, consistency diets.
the ITSE, International Dysphagia Diet Standardization Initiative, you know, those are the diet levels and liquid consistency levels. I think they already do receive information and education on ethical considerations, so that remains. Any other suggestions proposed?
Is there a course, or where would you learn about looking overall kind of comprehensively at reasons that someone would have dysphagia? So like systemic manifestations or something like that? Is there some kind of coursework like that? Or where-
Etiologies.
that would go under etiologies?
I do think they have causes. So Will that fall under that?
Yeah, I think so. Causes, etiologies.
Yeah, I have that. Etiology and
Okay.
causes, aspiration, knowledge of assessments, diet, texture, consistency,
Good.
maybe a knowledge of that standards.
And I think also just knowledge of not just like clinical bedside assessments, but also instrumental assessments that are available. Again, they're not doing those, but they need to understand what those instrumental assessments are assessing, when they are appropriate, and the verbiage that's included in those. So whether it be fees or modified bariums, video fluoroscopies.
So similar to when we talk about the hearing aid trainees, some of the items are knowledge of versus.
Mhm.
so.
And did we talk about like maneuvers? Was that one of the?
We can
think
include
that
that
would
under the
fall-
treatment section.
Yeah, I think that would fall under treatment.
But I think we should include that word, the maneuvers.
Maneuvers.
Mhm.
And then just a question, is it appropriate for them to have some pediatric exposure?
Yes,
Yeah.
Absolutely.
And that's in there too.
across the age range, so I guess it would be
Yeah.
pediatrics through geriatric population.
That would be, oftentimes when we're looking at foreign trained SLPs, we're looking at, did they hit the 3 age ranges, right? So pediatric, adult, and then geriatric, so.
So the education
And-
should cover a wide range
Yes.
of age, even
Yes.
though they are
Yes.
only working on a certain
Right.
age group. All right.
And
Familiar-
documentation.
yeah,
Documentation.
Writing notes,
Yeah.
documenting.
Right. So we did note some of the items you have listed. We'll try to summarize it so it's
Right.
not an exclusive list, and we'll work with our reg attorney to create that list for you. Because we do have some changes, we'll have to make those changes and then bring it back to the committee for discussion, since I can't come up with
Right.
text on the fly for you. But yeah, that is the last of the question. I can answer any other questions, or if you have any questions with any of the materials or want to discuss the materials, you're more than welcome to do that now.
And I would just like to toss in here, the regulatory process is long, and I know sometimes from the outside it can seem it's taking the board way too long and it's so cumbersome. There's a reason. Anything that we do fast will likely miss too many things and be too restrictive or not allow you to do enough, and it won't actually improve the status that well. In keeping that in mind, as we are here at a SLIPA program right now, and I have heard from other SLIPA program directors that eventually they may want to incorporate some of this education into the basic SLIPA program. I think it might be worth the committee's consideration to think about, do we want to delegate to an ad hoc 2 members of this committee to have a stakeholder meeting next year with some of the educational programs about some of this, so that we're getting the kind of input? Because I mean, right now, right, we don't have WebEx here. We only have 1 training program director here. Could we have a Zoom or WebEx meeting with the ad hoc folks and get some input from the programs? What could this eventually look like if it's incorporated? Are we missing anything? How can we make this, it's not like the board has many chances to do things, but oftentimes we want to get the best product we can because it takes us so long to get it over the finish line. Might as well make it as robust as we can. And I think that might be worth looking at next year. I know we have sunset, so that is a big year. It's a big lift for us. But trying to do even a remote one with training program directors and maybe other stakeholders like hospitals and things, to invite those kind of stakeholders in and say, this is what we're looking at. what kind of education, training. We would like to get your input as stakeholders before we bring that text back to you again for consideration.
Yes.
Indeed, I was waiting for them to bring us their syllabus for
Right.
for all their training.
Yeah, I do want to let the committee know that we do have your request to get it into SLPA curriculum. It's just, it will be another rulemaking to do that, which would be beneficial to have a ad hoc committee to get some stakeholder feedback on that. So even though we're not talking about that, and you know it has been requested, we do have it for a future discussion. That way we get more information.
Yes, thank you for your hard work on this.
Thank
I really do appreciate it. I did just want to just make a quick comment that yes, we are working on expanding the scope, but there are still many roadblocks that allow speech language pathology assistants, LIPAs, to provide services to certain clients or patients that have Medicare, or there may be some insurance limitations, and I know that's also in guidance elsewhere, that any SLPA that provides this, or SLP that has their SLPA providing therapy with the bolus material, make sure that it is allowed for that certain patient for reimbursement purposes as well. So they need to be mindful of that. So that might be something too.
So we don't really, I mean, we could look into it. It's just, it's very, with SLP, it's a very unique world where there's private practice, hospitals, and then skilled nursing facilities. So we'll take a look at it since it is something I've been getting into a little bit.
I know we don't have to put it in ours,
but
I
we don't
think
have
it's
to, yeah,
good
we won't,
for them to realize that just because it is something, whatever passes at this level is just like, oh, we can do it now, but there are other things that they need to be mindful of.
That's correct.
That we're not being prescriptive of.
And most SLPs are familiar with that. Like, they're not going to provide services if it's not billable, right?
Well,
so yeah, that's the goal. You know, when the regulations go through, maybe we'll get more feedback of where this is happening or where it needs to happen. It's just too soon to tell. I just know that right now maybe we're gonna probably see these a lot in hospitals. So.
Yeah.
And you know, oftentimes what we have in the regulation might also have some, it's more like practical guidance, right? That just, you know, please be aware that you need to also look at what's allowed at your facility. So if your facility says no, then you need to follow your facility's protocols, right? So those kind of things, along with, you know, ensuring that you follow whatever higher standard is required by the person who's paying for insuring the thing. So oftentimes it's not in the regulations, but yes, as practitioners, you all need to know that and be aware of it. So
Teaching moment. All right. Okay. I'd like to ask for if there's any public comment from anyone present in the room at this time.
There we go. Thank you for bringing this topic up. It's really interesting to see where the board is at in this new process, which was new to me. I hadn't realized this was on the table for SLP assistants, which is very exciting. I think that as a program director of an associate's level SLP assistant program, lots of things come to mind, and my students and I are gonna have lots to talk about when we get to class next week. So thinking about the training part, of course, and looking at SLP assistants, the reimbursement piece is huge. One reason why I was surprised that you were looking at swallowing therapy is because it's not, there's not a lot of medically based SLP assistants right now. We want that to change, and having this in the law will definitely be a huge step in that direction. I think also thinking not just in medical settings, but clinics and home health across the gamut, that's going to be a really interesting discussion about what does that look like. So it's really been really fascinating to hear all of the nuances, and I like that we got to take the time and discuss that. I appreciate that approach, because I think as a training program, we really want to make sure that we are going to be factored in somehow, and look at, what infrastructure do we need to build in our facilities? Who do we need to partner with in regards to getting access for our SLPs to get trained? Is that something that's going to happen in-house? And, here at Cerritos, we offer lots of other health occupations. So we have nursing programs, we have dental hygiene, PT assisting. And so we actually have labs with mannequins in them. And so it's not a huge leap to think, oh yeah, we could add on to that. But we just, I think it's going to be really interesting to have those conversations about what does the training look like? Is there going to be pre-professional training that's going to happen in the college level, universities, and then professional training that you're talking about, sponsored by the employers. So those are just some thoughts that I have, and I really, just definitely want our associate programs to be a part of that discussion. And so I appreciate what you said, Charisse, about doing an ad hoc committee so that we can all put our voices in and see where that goes. Yeah, thank you so much. Appreciate it.
Thank you for your comment. Any other comments? Okay. Right, hearing none. I think we're good. We'll go ahead and adjourn our committee meeting at 2:34. We'll take a 15-minute break, and then we'll reconvene with which one's next? Which one? That's Hearing Aid Dispensing Committee meeting. 15-minute break.
Okay, good afternoon. I call to order the Hearing Aid Dispensers Committee. It is 2:50 on Thursday, December 4th. Let's start with the roll. Myself, Todd Borges, Committee Chair. Dr. Chambers.
Present.
Dr. Sanders.
Present.
Dr. White.
Here.
Vacant? Okay. Okay, so agenda item number 2, public comment for items not on the agenda. We have anyone in the public? That looks to be no. Okay. Item number 3, discussion and possible action to add and amend regulations regarding post-fitting counseling and foreign body in the ear canal related to hearing aid dome removal at Title 16 CCR sections 1399.125 and 1399.126 as used in the BPC sections 2538.11, 2538.36, and 2539.6. If we can have Ms. Larzano.
Thank you. Maria Liranzo here with the report. On December 1st, 2023, the committee delegated 2 committee members to work with staff to draft regulatory text that would define the terms post-fitting counseling as used in Business and Professions Code Section 2538.11 and foreign body as used in Business and Professions Code Sections 2538.36 and 2539.6, and permit hearing aid dispensers and dispensing audiologists to remove hearing aid domes. This is in response to an inquiry the board received in July 2022 asking whether there is any statutory or regulatory language that would restrict a hearing aid dispenser from performing a dome removal if appropriate training is provided and appropriate safeguards and policies are in place to limit dome removal to lower risk clients. The committee met on December 5th, 2024, May 15th, 2025, and August 21st, 2025 to review and discuss the regulatory text. The following are the changes made to the text at the last meeting on August 21st. We did amend section 1399.125B2 to require verbal identification of the second bend of the ear canal for each supervised removal. Also amended was section 1399.126A to specify octave frequencies to include 1,000 and 2,000 hertz, to the definition of significant air-bone gap, and as well as 1399.126 B to replace ear dam with ear impression blocking material in paragraphs 1 and 2.
Thank you very much. So we'll open for discussion. If we look on page 1 of 2, I just had one item myself on page 2 of 2 under 1399.126, a referral for medical opinion, section A, where it says the definition, the difference of 15 decibels or more between the higher air conduction and the lower bone conduction. The term, using the word higher and lower, I'm not understanding where that comes from unless that was already present in the regs.
That was already in the regs.
Okay.
Yeah, again, these are probably really old regulations, so they're probably using old language. You're more than welcome to update them. I've seen different definitions to significant air bone gap, but the committee is welcome to revise it in a language that is suitable across different industries that dispensing audiologists as well as dispensers, hearing aid dispensers are working. So.
Okay.
Is the sole purpose of that to say if bone conduction is worse than air conduction, that's not something to refer for since really shouldn't occur, which probably means it's a placement issue of the oscillator. You need to retest, because bone shouldn't be worse than air in theory. So is it just to specify that we're looking for an air-bone gap of bone being better than air rather than bone being worse than air, because bone worse than air means you should probably retest or figure that out?
That's probably what they meant,
Intended.
but it's really confusing to me because it's a 15 dB gap between air and bone in that frequency. I think there has to be some way we can describe it better than higher air and lower bone, because when I read that, I don't know what it's kind of a confusing statement. It really doesn't clarify it, to my mind.
Yeah, I think the sole purpose is to say bone has to be better than air.
Well, then, yeah,
Which
so then
means
we
it's
say
lower,
if
'cause
there's,
it's a lower
if
threshold.
there's a 15 dB difference
Yeah.
between, in that case, it would be, well, depends on what you consider higher and lower on the audiogram, right?
Well, it's a lower threshold.
Right, so, yeah,
So I get it because it's reverse, and which is how we always talk upside down
right,
language.
exactly.
Because of the way the audiogram works. But like if I referred to Dr. Chambers for someone that I had a 15 dB air bone gap at 1 and 2, and bone was 15 or 20 dB worse than air, what is she going to say when she looks at that? She's going to be like, this isn't a medical issue, this is a test issue, like you probably messed up somewhere. It's not a reason to refer having bone
Yeah,
worse
but
than
I
air.
don't know if necessarily saying it this way actually expresses what we're really saying. When I read that, though, it doesn't necessarily come to my mind, oh, you mean if the bone is 15 dB better than the air.
Mhm.
I don't necessarily read that when I read this. If we actually just said that,
That's what I was-
if
yeah.
there's a 15 dB difference where the bone is 15 dB better than the air score at those frequencies, then they have to be referred.
So what would you say, a difference of 15 decibels or more where bone conduction is better than air conduction?
Well, difference of 15 decibels or more,
Where
or actually where the,
bone conduction is better than air conduction?
yeah, where the bone is 15 dB better than the air conduction.
Yeah, and I think that's saying the
Right.
same thing, and if that's more clear, I don't disagree that would be more clear, and I
Yeah.
think that's fine.
I would prefer to see language that's a little more plain English and a little
It's
more clear.
confusing. Okay, and then in that same section, I would change succeeding to successive. I don't think that means, succeeding is the wrong word to put there.
Again, while we're already in it and revising these to be clearer, absolutely, time to update those things, so.
Okay. Other than that, I didn't have anything at issue with which we've discussed. Any other?
So should the
ma'am.
text, should we just remove the air and higher and lower from it so that it just reads 15 decibels or more between the air and bone conduction pure tone?
No.
No.
No, because we still want to say.
That the bone is better than the air.
The bone
The
is better
key
than
there
the
is
air.
that the bone is 15 dB or better than the air conduction score.
So between the bone,
So a significant air bone gap means that the bone conduction score is 15 dB or greater than the air conduction score within that same frequency.
is, okay.
Probably how they ended up here with trying to
Right,
use this language.
but and there might be an easier way than how I just described it, but the way I said it was much more clear of what we're actually looking for than.
Is that,
than this,
so
I
I'll,
think.
I would like to ask, Dr. Chambers, that your understanding of a significant air bone gap?
No, it is. I do understand what they're trying to say. I understand both ways.
Okay.
I don't know how to make it clearer.
Let's see. Significant air bone gap.
I thought that was pretty clear. But
What I had was what you were reading, that it's a difference of 15 decibels or more where the bone conduction pure tone thresholds is 15
Well,
I'm going to say decibels,
So if we say-
better
yeah.
than the air conduction thresholds.
Right, so if we put bone conduction before 15 dB, right? So if we say.
Yeah, that's how I
Means the
have it.
difference between the bone conduction pure tone threshold and the air conduction threshold is 15 dB or greater.
What about,
AACE means
You
the
prefer
bone
that?
conduction is 15 decibel or
Or
more
more.
than the air conduction.
where, I think you can keep it the same. So a significant air-bone gap means a difference of 15 decibels or more where bone conduction is better than air conduction at 2 or more successive octave frequencies.
Successive or consecutive.
Yeah. Did you get it? Want me to say it again?
I would love you to say it again, and then we're going to probably watch it and literally type it from like what
Okay.
you're saying.
So starting at A, so a significant air-bone gap means a difference of 15 decibels or more where bone conduction is better than air conduction at 2 or more successive octave frequencies, blah, 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 blah.
Okay.
Yada, yada, yada.
Hinting at the fact that it's hard to wordsmith and adopt as amended right here, right
Yeah.
now, if we're tackling this. And then sometimes when we bring it back to you guys, when you see what we did in committee, it doesn't look exactly the same to you. So potentially rewriting it, and then I hate to say it, but have you come together one more time and, or you
In
want
that
to, you
case-
want to
in
approve
that
it as
case,
amended?
Leave it alone. I would say, I would rather approve it as amended, because if we have to come back and talk about one sentence one more time in this committee to get this thing moving
That's-
along.
I mean, yeah, we could, because it will be looked at again to
At the board
prepare for
meeting,
the
yeah.
board meeting, so it might just end up being a question there. Because
changed
we
my
will
mind.
have our legal attorney, we'll let her talk about what you had proposed and if that makes sense, from a regulatory legal perspective. But, okay, so we've noted the changes to that. Are there any other good questions or recommendations?
No, you got the succeeding part changed, right?
Successive.
Successive, and
Successive or-
you said and consecutive, is that?
Consecutive, because it needs to be adjacent.
Successive and consecutive?
No.
No.
You can just pick one.
No.
Yeah.
No.
I think
It can't be the difference of 500 hertz.
You need to put the mic on you so you can.
It can't be the difference between 500 hertz and 4,000 hertz. No one cares about that. It needs to be two adjacent frequencies.
Continuous?
Continuous, adjacent,
Contingent?
consecutive,
I think that's successive, yeah?
successive.
Yeah, so this one was, like I mentioned, I did found some different definitions. Like I think OSHA has their own definition and requirements to this definition compared to the FDA disclaimer for hearing aids. So it could be something that when we do prepare it for the board, we could bring those language as well, so you could look at it to make sure it's broad enough to cover either things,
And as we're looking at it, the definition of successive is following one another or following others. So
yeah.
It's the same.
it's, yeah. But if you wanted them literally
Succeed.
They're
consecutive, it
synonymous.
needs to be.
Yeah, succeeding is not the right word.
Yeah,
Correct.
successive
Yeah,
is.
yeah. Successive.
is fine. Continuous.
And I would always say if we're looking between OSHA and the FDA red flag conditions, I think in terms of dispensers, we would always be more consistent with the FDA red flag.
I was going to say I would prefer to slant to the FDA versus OSHA in that regard, because that's what we're basically tracking,
Okay.
Held, standards held to.
our red flags.
And just so everyone's aware, the FDA has certain warnings on devices, and we're talking about hearing aids, which are an assistive device, and so they do have some of those warnings on those products.
Any other discussion?
And no
Okay.
motion, because we have to we're changing too much, so we can't have
Can
a
we
motion?
just do it as amended?
Yeah, you can make a motion as amended. I know there is motion language.
Yeah.
Just
And-
make sure
and
that
does-
it says
and it does say as amended on it.
Yes.
Yep.
Okay, so I'll move to recommend the regulatory text for Title 16 CCR Sections 1399.125 and 1399.126 to the board to initiate the rulemaking process as amended and direct board staff to prepare the regulatory text for board review and approval.
And I second it.
If we can open for public comment. Seeing none. Ms. Burns, if you could call the roll.
Absolutely. Mr. Borges?
Aye.
Dr. Chambers?
Aye.
Dr. Sanders?
Aye.
Dr. White?
Aye.
Motion passes.
And that being our last item, I will adjourn to the next meeting. 5 minutes?
Do we need 5 minutes? Or
You
do we
want to, can you roll right into it? That's fine. Let's roll right into it. Do we have everyone here?
Just three of us, right?
Yep. Well, I believe, is it Karen?
You need to swap Todd for Karen. That's why I said 5. I'd say you get better into that deal. 3 minutes.
All right, so I would like to go ahead and call to order the Audiology Practice Committee meeting at 3:07. We'll go ahead and call roll. So Amy White, Dr. Chambers,
Present.
Ms. Chang,
Here.
Dr. Sanders.
Here.
Thank you. All right, so we'll take a moment for public comment for items not on the agenda, if anyone wants to come forward. All right, seeing none, we'll move on to agenda item number 3 for discussion and possible action to add and amend regulations regarding general application requirements and speech-language pathology aid and audiology aid requirements and scope of activities, duties, and functions at Title 16 CCR Sections 1399.151.2, 1399.151.3, 1399.151.4, 1399.154 through 1399.154.12, and 1399.157. If Ms. Lorenzo wants to present this agenda item, please.
Thank you, Dr. White. On November 30th, 2023, the committee directed board staff to amend the previously drafted proposed regulatory language that would implement statutory changes relating to audiology aids. The committee met on September 5th, 2024, and December 5th, 2024, to review and discuss the draft regulatory text. At its August 21st, 2025 meeting, the committee met to discuss levels of supervision and responsibility required of an audiology aid. The following changes were made in response to the committee discussion at its last meeting. Section 1399.154 was amended to define industrial aid as an audiology aid and not a person. Actually, that was a board staff change, not a committee change. The next two changes were made from the discussion, which is section 1399.154.9 was amended to permit indirect supervision following initial registration, include clerical tasks and servicing hearing aids under indirect supervision, as well as 1399.154.11 was amended to add altering hearing aid programming or setting as outside the scope of responsibility of an audiology aid. We do have a couple questions for committee discussion, as well as meeting materials.
Okay, so question 1 has to do, the question is, are screenings the same as evaluations? Would screenings be within the scope of responsibility of an audiology aid?
No.
No. So screenings aren't the same as evaluations. Are screenings within the scope of responsibility of an audiology aide?
No, when I go back to the school audiometrist license, those people have to be licensed in order to perform screenings in a certain way. So audiology aides would need to have some level of training to do that. Where are they going to get it? How are we going to recognize it? All those things, I would say no.
I disagree with you wholeheartedly. Yeah. Yeah, I mean, so in this instance, unlike school audiometrists who don't have an audiologist on site to look at their work, hence they need additional certification and training. And when we're talking about an audiology aide, they're under the direct supervision and on the license of the audiologist. So I think that's completely different. I mean,
if they were working at a physician's office?
what? Microphone, can't hear you.
What if they were working at a physician's office and there wasn't necessarily an audiologist there, but the ENT was there?
You can't have an audiology aide working without an audiologist.
Even when they're not present. So
That's-
they work there, they're their supervisor, but they're not necessarily present during the screenings.
I would think you might find some of the issues in the regulations about you have to be assisting the audiologist, and this is why aides are not there to perform, they're not there to be a SLPA, essentially. They're not there as an assistant role to work after a certain amount of training independently. They are there to assist the audiologist in the room with that. And so that's where we would want to.
Yeah, and so again, the definition, we have different levels of supervision for aides. There's the immediate, especially for new services they're providing to the client, or the after initial registration. Then there's direct supervision, which is immediate is the audiologist would be in the room with the aide. Direct supervision, the audiologist is in the facility, so in that case, the aide is providing services, probably preparing the client for an assessment or an evaluation, or maybe helping them work their hearing aid, like connecting it to their phone and telling them how to set stuff. And then indirect, like I mentioned, it's clerical and like servicing hearing aids and cleaning.
So an audiology aide just needs direct supervision, not immediate. I can't see a circumstance where I would stand there and watch an audiology aide conduct a screening. I would just do it myself. I don't need them.
You would be in immediate supervision if you were just training them how to do it and you were verifying that they were understanding what to do.
And then later on.
Correct, and that's how it's written, is
Yes.
the immediate supervision is required, like if they're going to be taking on a new task and they're learning that new task until you determine that they're competent.
Yeah, so the screening would be most likely taught by the supervisor. And so that's why I'm bringing it up, because I know for SLPAs, they're allowed to do screenings on their own under direct supervision. I'm not I just wanted to make sure that we consider that for aides, especially because, most of them are probably, it sounds like, going to be bachelor students. So it's like, well, are they having any kind of education or experience and realizing,
we were just talking to those guys, and they all had a special
But
thing that they're doing for
technically, an audiology aide
Doesn't
have to
have
have
to.
any
No.
education. They
Exactly.
could have come off the street and be anybody over the
The
age of
school
18.
audiometrist does. They have 6 units of upper division.
And
Yes.
that would be the
Audiology.
difference. So again, audiology aides, no education requirements, could have just come off the street.
And a school audiometrist is then making a decision about what to do with the patient now, the client, the kid.
Right.
Do they need a referral? Do they need, they're operating rather independently with that. Whereas an audiology aide is working under direct supervision on your license as an audiologist. You're reviewing all of that. You're making those determinations. They may do the screening and then they're coming to you to go over the results. And in my mind, I would see it as being used as a way to know, does a full diagnostic audio need to happen? Was there a significant change? Things like that.
On the next page, I did identify some what's consider screening tools by
Right.
Medicare,
Right.
and then also our definition of hearing screening for
And
the
they're
purpose.
two different things.
Yeah, to get more clarity of if it's permitted, if it's something an aide could do under the supervision of an audiologist.
Right, so it's, is a screening a pure tone air conduction threshold test? Or is a screening, I'm setting the dial at 25 and you either hear it or you don't? Because that's, Medicare is defining it as a pure tone threshold, air conduction threshold only test. And the section 2530.2 seems to be defining it as you set it at 25, did you hear it or not?
And that's what it is for the school. They're setting it at a single frequency, pass, fail, that's it.
Right.
So what's the question?
So I guess the question is, are there screenings they shouldn't be doing, and then and if we just need to specify the screening to be the hearing screening as defined in our statutes, whereas we're not just saying screening to include all these other screening that Medicare has, which is like air only, pure tone tests, evoked auto acoustic emissions, and some
The Bekishe audiometry,
yeah.
which nobody does.
And then again, whether or not the aide who doesn't have any education, doesn't have to have any education, can be doing it.
Yes.
Right, but nor do the newborn hearing screeners in the hospital that does the otoacoustic emissions and then sends them off to audiology.
Yes, that's
when they fail.
That's who I was. The evoked. I noticed that could be something that you could do. So yeah, that's why we're bringing up the question, because I did notice it was not in the text of the regulations.
So my thought is maybe irrelevant. The use of an aid right now is so narrow that we don't use them. Okay, so it's not really a useful position to have in a practice. So I think we're trying to better define the use so that maybe they'll be more used, which we need for the profession to continue, right? So, but understanding that, it's not equivalent to a SLPA. SLPAs have required education whereas an audiology aid does not, which is why this whole discussion that, the state association's bringing up about creating an audiology assistant category is relevant. So on the one hand, I want to look at I don't want to be giving an aid too much scope when really that's something that probably requires more education. And if we give an aid a certain amount of scope now and then the assistant comes up, are we able to go back in and then make those adjustments if there's too much overlap?
I would tell you that your goal right here and now is consumer protection, and that as it stands, if you're looking at an audiology aid right now, no education, no special training, comes off the street, what should be allowed? And that is what we need to define as the audiology aid's scope. And then as the association addresses we'd like to allow people with more education and maybe a bachelor's or an associate's program that could be developed for audiology assistants, that would be a separate conversation, because right now we need to look at what is the scope for the people that do not have any education and training, that come right off the street.
But they do have to have training to get the aid certification, because I have to submit a training plan of how I've trained the aid and how I've tested their knowledge and made sure that they're competent in each area.
That's how you're going to train them, but that means you're doing that right then and there, right?
Mm-hmm.
So it could be that's my plan, I'm doing it right now, and now I'm registering them, but that's a pretty limited amount of education and training. So at that limited amount is what you should be looking at. So if it came off the street, I made a training plan, I gave them however many hours of training at my clinic, then I'm going to go ahead and register them. What does that look like? What screenings should be allowed when you're on site but you're not in the room? Or similar to speech aids, anytime there's therapy being provided or anytime blank is being done, then the speech language pathologist or audiologist needs to be in the room. And sometimes that may look like the aid is only there to help clean and put out the therapy materials. They schedule the patients. They do certain things that are very specific and limited. And then that very clearly defines there is a big gap between the aid and the audiologist, And when the association does its work to determine what the assistant ought to have, it's in filling that gap.
So being able to go out to a health fair with your aide and have them do it, set the dial at 25, they either hear it or they don't, versus a threshold search.
I like that better.
25 dial.
25, that's it.
So
'Cause especially if we're limiting somebody with actually has a bunch of training, like the school audiometrists, we're limiting them to just that.
Mhm.
We can't give people with less training more than them.
Okay, so we would go with the definition that's already in BPC section 2530.2 and 1.2.
So does that
Not
mean
the
we're
Medicare
sticking
one.
with where Dr. Sanders started with no and screenings are not allowed?
No.
Okay.
It
That's what I want to
means-
make sure I'm
No, no,
circling back.
Screenings are allowed, but
Definition of screening.
But screenings are defined as the BPC section 2530, not the Medicare definition.
Got it. Thank you.
'Cause then when you start looking for threshold and these other things, we start getting into evaluation territory.
Arguably, but I'll give it to you. Okay, so then number 2 was, does the fitting, selling, or independently adjusting a hearing aid is used in section 1399.154.11J have the same meaning as the practice of fitting or selling hearing aids as defined in BPC section 2538.11? And I wrote no, it does not. But I did circle some things. I don't know what you guys felt. And I guess it's arguable. I think I had circled post-fitting counseling as being a question. Under the 2538.11 quote.
And again, to reference, this is a section that we are talking about activities outside of the scope, so not allowed by the audiology aid.
Right. I have a hard time with post-fitting counseling for that reason, because post-fitting counseling can be construed as how to put the thing in your ear, or how to clean it, how to change the battery, how to use your charger, how to use the app on your phone, which are all things that are in the instruction booklet that the patient has. So I'm worried that I don't want to limit the aid to not being able to assist with those types of tasks because it's under the umbrella of post-fitting counseling. I don't know how wide that umbrella is. I think we've talked about it a few times.
The language is vague, and some of you are on the hearing aid dispensing committee, and it is something that is expressed to clarify a little bit more. I just want to make sure that the language that is in the regulation in no way exclude that aspect. That it's very clear that when we're talking about fitting, selling, and independently adjusting, we're talking about the ear mode to create the hearing aid, placing the hearing aid and making sure it's fit. That's done by an audiologist, right?
Or dispenser.
Because especially the initial fitting where you have to make sure the setting is right.
Sure.
Right. So that's
the
an
size.
aid wouldn't that action is covered by these words.
Yeah, and that's within the initial fitting of
Yeah.
the device rather than the follow-up coming into the office or practicing, techniques.
And so
And I think we've talked about this in the Hearing Aid Dispensers Committee as well, which is, your front office staff should be able to do anything that the patient should be able to do themselves that's in an instruction booklet where they're just further assisting with, here it is in the instruction booklet, here, we'll practice it together, that wasn't crossing over into the hearing aid dispensing territory. And I just want to make sure that we're the same for the aid, because I think that's the ceiling.
Because this is a negative response to this regulation, is there a way to put in what we're doing to say that this post-fitting counseling is possible?
Well, we're not using the definition of practice of fitting or selling hearing aids. We're specifically stating that
you can't fit, sell, or independently adjust a hearing aid without a hearing aid license.
Can we make
As
that
a
the end of the statement?
And
Yeah.
we're being more specific because we're saying it's not in reference to the other section. So we just want to make sure that's what
Yeah.
the committee intends, is that we're not specifying that because there are some little bits of post-fitting counseling that might be included in this, like pointing out where in the booklet and how to charge your hearing aid and so on.
So do we need to change it?
It doesn't sound like, I think, for me, I guess, can I get some clarification what adjust looks like in your profession?
Programming. Making a programming change.
You ever make a gain change, an intensity change to the
Okay.
device?
We might want to change that because to me, adjusting is like this, placement, physical placement. Whereas that might be, programming is very specific, but I think
Can we add that in a programming adjustment?
yeah, I think I have it somewhere else. Hold on.
I didn't think we had programming.
Yeah, because having an aid, have the patient practice taking it on and off the ear and make sure they have it seated properly is totally appropriate.
That can be an
Oh,
hour.
let's see.
It's okay. So yeah, under C, we did alter treatment plans or hearing aid programming or settings. So maybe we might want to just remove it. So it's just says fit or sell hearing aids without possession.
Oh, lock your microphone.
But wouldn't fit also involve adjusting in the ear?
That's also just it's how we speak
Yeah.
in dispensing and audiology. It doesn't mean fit like it means the initial programming, but it's unclear. I mean, I understand why it would sound.
Yeah, to me,
that way.
as a
Yeah,
lay person, I'm
right,
like, I don't know,
exactly.
like to me, it's just like there's this adjustments and changes and fitting, and then there's the programming. So I'm
Because
just
we
like,
use fitting, the word fit is the initial appointment for the patient to receive the device and have it programmed to their needs. That's what a fitting is when
What
we
about
say
making
fit.
sure it's not uncomfortable in the ear? Or anything?
Sure, make sure it fits too, but it's not really,
It's not about that fit.
No.
Is what you're saying.
correct.
okay.
We might want to work on our words and definitions.
Well, and again, I think it's because it's just a common term that hearing aid dispensers and audiologists use. I mean, you call it a hearing aid fitting appointment. It's a hearing aid fitting. That's always that initial appointment to get the device programmed to that patient's needs, and then everything else is a follow-up. So you have a fit and you have a follow-up. But it isn't clear to people who aren't part of the profession.
Because otherwise, we might be introducing a term, and that's, I think, where you're getting right. Because if we're saying independently adjust, what do we mean?
What are we adjusting
Yeah.
is my question.
The programming.
Like the programming.
Okay,
Programming,
because
because
then
that's
you-
the prescription.
Because there is already alter treatment plans or
Yeah.
hearing aid programming and or settings. So we might not need independently adjust if
Yeah.
that was only intended to mean the programming in C, so we could remove it from J. Unless there's another meaning for independently adjust.
Is there?
Sorry, I know this is getting super technical on the wording, but yeah.
Yeah, I don't think that's necessary.
Okay. So then we could strike it. So it's just fit
Yeah, I
or
have it
sell.
noted that I'll just say fit or sell hearing aid without a valid license.
And if we need to change fit to be further defined as the initial appointment upon which the
But not only, just any adjustment of the programming and the gain of
correct,
hearing
but
aid.
fit
That
might need to be
Initially and
replaced.
later.
Yeah, we're talking about, so when we're talking about fit, I'm thinking of what's done in the practical exam where like you're checking that can sit in there. I don't have hearing aids, so I don't know, but I'm assuming that's like an actual, like making sure it was created correctly to the patient.
Sure. And that's one component of a fit.
Yeah.
Since there's a variety of hearing aids, some people are just putting a little dome in their ear, but some people might have a custom ear mold
Yeah.
that goes into their ear, and you want to ensure that it properly fits,
Not
and it
causing
doesn't need to be
sores.
shaved down to properly be inserted in their ear without discomfort and pain.
Right.
Right?
Mm-hmm.
Okay.
Absolutely.
And that's
I
where we
learned a
don't
few
want the
things along the
aid, And that's where we don't want the aid doing that.
And the aid shouldn't be
Correct,
doing
yes.
that.
Correct.
So,
So that makes sense. Yeah, no,
Okay.
it's just, so when I am writing regulations, I have to
explain why sometimes I use the word we're using. So it helps to say like to fit means like to shave, or if it's a custom ear mode, they'll have to so it gives me more like actual technical information to give.
And I'm just going to, again, we have people in the audience. It's a wonderful educational moment. When we write a regulation, we have to provide an initial statement of reasons. And we need to talk in plain language to the public and consumers about why we're making these changes, what do we mean when we're making these changes, and here's why and what we considered as we want to make those changes. And then the public has the opportunity during a public comment period to write or show up to a hearing and tell us whether or not they agree with that and why. And so this is all part of this very long state-required regulation process, but that's also what makes sure that we haven't missed anything. And that the whole conversation of what does it mean, are we clear enough, is it, and one aspect of the Office of Administrative Law, which is a state agency which does this process with us and ensures we follow the state mandated process, they're going to say, is it clear on its face? What does it mean? And so then, is fit or sell clear? And then when we got to independently adjust, was it clear what that meant, right? So,
is the committee wishing to make a motion on these language? Because if so, we'll probably need to go back to 1 to make sure we have a text, a location for it, and what the language would look like.
Or update it and bring it back to you at the
Yes.
next committee meeting. Sorry, I know it's a very iterative process, but.
Well, I guess my questions is still, are we trying to further define fit? Is that what we're trying to do now? Or are
I
we
don't
gonna
think
leave
so. The information you provided makes it clear what
Okay.
it means and how it differs from like the practice of fitting and selling. So I think it's fine as it is,
Okay.
since it is. I mean, sure, I have an idea of what it is. Therese has an idea of it. You guys have an idea of what it is. So yeah, just when I'm writing the ISOR, it'll just be that specific moment in time.
So what needed further
The
clarification?
screenings.
The
question
screening, the language. So it sounds like screening as defined in our Practice Act is permitted.
Yes.
So we either need to define it. There's, I guess, 2 ways that it can be defined. Either that it's permitted as defined, or it's not permitted if it's not within this definition.
Yeah,
if that
it's
makes
not permitted outside of.
Yeah.
This is where wordsmithing in public is hard, but yes.
So audiology aides can perform hearing screenings as defined by, can you just refer to that section, or you have to rewrite it again?
No, I would reference the business
Yeah,
code section.
I like that.
That hearing aides can perform screening as defined in this section.
I think that's it.
And which section were we looking at putting that in?
It would probably be the one before the outside the scope. Let's see, that's 14.
In the training?
13, wait. Supervision, I don't know. Maybe under, yeah.
So it sounds like we would want to put it somewhere that it is permitted as defined. And we're going to either need to put that in the supervision or in the responsibilities section.
Would it be 1399154.11?
No, that's outside the scope.
Yeah, that would be when you're not allowing
What about
it.
1399154.1?
I think it might go in 1 in the talk about, well, that's more about the registration of them.
Yeah.
And that's more about the registration process.
So you're going to have to put it in the negative, because you're going to have to make
Yeah, I
it,
think
you're going to have
so.
to put it in the
Yeah.
disallowed, and the disallowed, so it's going to have to say,
Yes and no,
No?
because there is a section,
Outside of school.
Disclosure. I thought there was an area that
It-
said they're
it's
permitted.
usually- and I know it sounds weird, it's gonna be like the responsibilities of the supervisor and the training. As odd as it sounds, that's kind of where we talk about what they're allowed to do and how they're allowed to do it. I really gotta get bifocal so I can.
Registration.
But that's oftentimes, so again, we don't like, so regulations, if they specify a bunch of things you can do.
Right.
Then it becomes an exhaustive list under the law.
We don't wanna
And
do
that
that.
exhaustive list would then say you can't do anything outside of those things. So oftentimes, we err on the other side, which is, here are the things that are outside of your scope. That thus being, everything else is inside your scope, but you have to do it under the supervision and under the responsibilities. So we would define when and how you're allowed to do it in the responsibilities and the responsibilities of the supervisor and the required training. So, as weird as that sounds.
So if we add it to outside the scope, it could read that an audiology aid cannot perform, cannot conduct a hearing aid that is not defined in business and profession code.
A hearing screening that is
A
not
hearing screening, yeah, that is not defined in
that
those two
section.
sections, yeah.
I almost think that's where it's gonna have to go, Sharice, because I'm looking.
And that seems really simple.
The other option was in 1399.154.4 on the training. Oh, nope,
That's speech.
That's aid, sorry, wrong one.
Yeah.
Yeah, we're
Training
back.
It's
of-
1399.14.10, training of an
Thank you.
audiology aid.
Yeah, that would be, so that we could specify that training has to be provided to be able to provide
To
that
do those screenings, you
screening.
have to provide that training.
Yeah.
And the screenings are only those defined here.
That would be good too.
So that's, I think, so in point.
Yeah, so it'd be
10.
similar, so it'd be similar to D where, supervisor provide training to an industrial audiology aid to perform the duties for hearing conservation. We could say for E, a supervisor shall provide training to an audiology aid
To perform
hearing
perform
screening.
hearing screening as defined in the section.
Yeah.
And insert it into point 10, 154.10.
Yes, as E, right? Yes.
I might make it D, so that the industrial audiology aid always sits as its own as the last one,
Mhm.
personally.
Okay.
Because the
Agreed.
rest of the section is about regular audiology aids, so if it became the new D,
All right.
and then we can work with our regulatory legal counsel on the wordsmithing of that, and then bring it back to you.
So we can't make a motion as amended?
Sorry.
That's okay.
If you're modifying what's already there, I'm far more comfortable doing that in person and on the fly. If you want to create a section, I hesitate. Sorry.
All right.
But hey, I get to meet with you lovely people more often, so.
Exactly.
Yay, you're welcome. Sorry, I know. But I do think it's important because, again, what we see out in the field is that if you don't tell them, some employers will decide on their own that, oh yeah, my aide can do all of these things. And you're like, I'm a little concerned with what you might be allowing them to do. So if we want to do it, we could put it in there and it'll say essentially, yes, that's saying audiology aides can do it because it's not prohibited, but they can only do it in accordance to this, which is with this training and under these sections and these types of screenings.
Yeah, and it could be that we'll probably need both. Like, I could probably see our regulatory counsel saying that we
They
need
might.
both, just to cover what Sharice mentioned, to make sure that
Yeah.
people aren't doing screening that they shouldn't be screening, but as well as making sure that they're getting the training they need to provide the ones they can do.
Yeah. So that way it's very clear. So yeah.
Okay.
Sorry to take away your motion.
So since we aren't making a motion or taking a vote, do we open up for public comment again?
If the board is done with its discussion.
I just have a question about the next little orange piece of paper that now says audiology assistance on it. Why is this included?
Yeah, so they were included as just to be able to compare the
What some
a
other
SLIPA from
states-
a SLP aid, as well as what ASHA has proposed as an assistant, so that you can see of like, because that's where I got the screening. Because I saw it for SLIPA that they can do screening, so that I didn't see the language in here in the reg. So when I looked at ASHA assistant, they had screening for their assistant. So I wanted to make sure that we had that discussion, because it's my understanding that they were different, but just wanted to make sure in the practice of audiology, it's the same, and that we've had that discussion. So yeah, they're just there for reference.
And then I would even tell you, when we get questions, right, we'll get questions. I'm an aide and they're having me do this screening. Well, they call it a screening, but it's really an intake form. So a lot of times, sometimes in clinics, different words are getting tossed around, but it might just be an intake form that the initial patients are doing. And then when we get the complaint, we then go take a look, and we have a subject matter expert opine on it, and you're like, no, that's just an intake form, and that's not really a screening per se, like the screening's defined here. So if we can be as clear.
Well, I
when we
get
do
that because online, so many times on these websites, an online hearing screening is a questionnaire.
Yes.
Not any kind of.
Not an actual hearing screening as defined, exactly.
How do you feel your hearing is?
Yeah, how do you feel? Yeah. So, and that's why we want to talk about it here, because again, it's taken us so long to get to clarifying the aid. We should make it nice and strong. We've put in all the effort and get it nice and clear.
Great.
Any other board discussion? No? All right. Open up for public comment. If anyone has a comment, welcome to come forward. All right, seeing none, I'll adjourn the Audiology Practice Committee meeting at 3:43. 5 minutes, 10 minutes?
So at this point, the board is now going to reconvene and close. I'm not on the microphone, I apologize. I'm just loud. At this point, the committee is going to adjourn. The board is now going to reconvene, but they are going to go into closed session. So that is not open to the public. They will go ahead and close and go into closed session in order to perform my evaluation. And I cannot find the page under the law. We'll have the board chair come back up and reconvene so that we can do that. So if we can have our board chair and all board members return to the board dais, we will go ahead and reconvene and go into closed session. Yeah, we can give 5 minutes until 3:48.
Okay, at this time, I am reopening our Speech, Language, Pathology, Audiology, and Hearing Aid Dispensers Board meeting at 3:49 on Thursday, December 4th, 2025. I will start with roll call. Gilda Dominguez, Chair, present. Dr. Amy White.
Here.
Mr. Todd Borges.
Here.
Dr. Tamara Chambers.
Present.
Ms. Karen Chang.
Here.
Mr. Francis David.
Here.
Dr. Charles Sanders.
Here.
We have a quorum. I'd like to ask for public comment for items not on the agenda. Looking around, there are no members of the public present, so we will go ahead and move to closed session. Agenda item 6, pursuant to Government Code Section 11126A1, the board will conduct the annual performance evaluation and consider the salary of its executive officer. We would proceed with that part of the meeting at this time. So this now ends the public portion of the board meeting, and we will adjourn the meeting from closed session and reopen the meeting tomorrow, Friday, December 5th at 9 a.m. Thank you.